Hi, welcome to Housing Houston. On today's episode, we have very special guest Mike Goehring with the Goehring Law Firm today. I'm Sarah Lerner with Real Vest Property Management. We are missing Kayla Ewald today, so you get me. But we're going to jump right in. Mike, welcome.
Thanks for having me. Happy to be here.
Yeah, I'm excited. So to all of our viewers, please start by telling us a little bit about yourself, what you do, and your career background. How'd you get there?
Sure. Well, my name is Michael Goehring, and I'm the owner, managing partner, whatever you want to call it. I'm the only attorney at the Goehring Law Firm, PLLC. We started back in March of 2023, so we're about to hit our 3-year anniversary.
Congratulations, that's awesome.
And we're finally, getting to that point where you're a little bit more comfortable and not as terrified, really, of getting out there. Right. So my background, and when it comes to legal background, I started off working when I became licensed attorney at a boutique real estate law firm, pretty much doing the exact same things that we're doing now. We did handle more litigation matters there. Our law firm has taken on several litigation cases, but we're trying to steer away. And our passion is really helping investors make deals, closings, and make money ultimately.
Yes.
But prior to that, I worked at ExxonMobil. I've worked in public accounting. I'm a certified public accountant. And so back then I didn't even have a thought about real estate other than I loved real estate, but I didn't have any experience. So my passions have led me to it, and I'm finally here.
That's awesome. So CPA and attorney, that's a wicked combo. I like it.
It helps, I guess, sometimes.
That's fantastic. So I bet you know a lot about creative financing then and can help structure a deal, look at the numbers, and advise accordingly.
Yeah, definitely. That's one of the things we like to focus on. We work with a lot of investors, not necessarily just investors who we help with that, but putting together deals, drafting the legal documents to facilitate that transaction. That could be basic seller financing of your primary residence. Could be more investor oriented with, assumption transactions, taking over an existing loan. There's wraparound transactions where you're creating a whole nother loan around a loan that already exists. And then there's kind of the frowned upon subject to transactions, which can be, they're pretty messy. I mean, they can be messy, but there's a legal and proper way to do them. So we guide clients through that process.
That's fantastic. I'm actually going to park there for a minute because what we're seeing in real estate is it's a really hard time to be a seller. And so our agents and sellers are looking for any creative way to get this property sold. So can you tell me a little bit more? I'm just going to start by asking for definitions, and then we can kind of talk through pros and cons of each approach. So Sure. Tell me more about a wraparound loan. Like, when would that be appropriate, and maybe tell me what it is?
So a wraparound loan is a perfectly legal type of transaction. Title companies will insure it, but it's gotten a really bad rap just because.
Okay.
Oh yeah, no pun intended.
Get it?
No pun intended. It's got a bad rap, or reputation, just because investors, people who are creative and know the industry,
Sure.
know how certain things work. They know where there maybe isn't as much oversight, or there's an opportunity to defraud people.
Sure.
And so with wraparound transactions and even more particularly subject to transactions, there have been a lot of consumer type of violations where people have been taken advantage of. But they're legal transactions, and so we make sure people do them correctly. But what it is essentially is, let's say you have a loan, mom and pop have a loan and they want to sell their house, and they don't want to just do an assumption where the buyer is going to take over that loan and make sure they make payments on it,
Right.
And so what they can do is say, well, here's our loan. We have $100,000 left to pay it off. We're paying 5% interest. Well, that seller can say, well, we can actually make money on this loan or the sale by issuing a second loan, as long as that principal balance we're selling for is going to be higher than what we owe on the underlying loan, our personal loan. And then the interest rate is also higher than our interest rate. So we have a little bit of arbitrage where they can be making, some interest money each month on the payment. They're taking that payment from their buyer and they're applying whatever the, portion that needs to go to their loan is, and they keep the rest. And hopefully there's some profit left after that.
I love it. Tell me about why would a buyer want to do something like that?
Well, generally, from the buyer standpoint, it depends on what their position is, right? It could be somebody who's very sophisticated, or maybe it's someone who just really doesn't have any options to get conventional financing. Those are a lot of factors that we see that go into seller financing in general, any type of lending from a seller. So if, for the average buyer, I guess, just your average family, it's going to be easier to qualify for that mortgage, right? No matter what type, if it's just seller financing, assumption, or a wraparound, because they're not going through all those rigorous checks that a commercial lender would generally, check the box and make sure they do. And then that can kind of lead to some other issues too, because there are still legal requirements.
Sure.
But just from the standpoint of the ease of getting that loan approved and getting into that house, it's going to be a lot quicker. Generally.
So you said there's other legal requirements. Can you maybe hit on that for a minute? And I know I'm going to pause here and say this is not intended to be specific legal advice. This is just general education.
Correct. Yeah. And I want to reiterate that. I'm not providing any legal advice. This is purely just for educational purposes, and hopefully something that I say can help somebody in some way.
I feel like it already has. So tell us a little bit about the legal requirements for a wraparound loan, or even subject to.
Okay. So for a subject to, an assumption, a wraparound transaction, all of those come with, just because of prior predatory lending and just consumer, taking advantage of the consumers in the past. The Texas legislature has enacted certain disclosures that, they're pretty stringent, but they need to be fully disclosed when it comes to a wraparound. You have to fully disclose that I'm transferring this property to you. There is an existing lien on this property, that if any time I don't make those payments, which you, the buyer, may or may not have any clue whether I'm making those payments, other than me just signing a piece of paper saying I'm going to. But in the future, I may hit, hard times and miss a couple payments, and you could be current, and I'm taking your payments to live off of instead of paying the underlying loan. Now you're possibly looking at foreclosure. So there's a lot of disclosures just to clearly state in an unambiguous way. Usually it needs to be bolded, capital letters, all capital, very conspicuous on the documents. Right, just to clearly make sure they understand what it is they're getting into and the risks that they're taking on by doing so.
Absolutely. That's great. Tell me a little bit more about, have you seen any other types of creative financing deals that are legal here in Texas? I know we talked about wraps, talked briefly about subject to. I will say I see a lot of people making subject to offers. So when I do real estate, usually we'll get, sometimes tens of offers that come in that are these investors looking to make subject to deals, mostly because, the interest rates were so low and now they're so not low.
Well, with subject to, those have the worst reputation in the real estate lending industry. And they're very similar to a wraparound transaction, with one very important difference. The difference is that the buyer is not actually making any additional promise or any promissory note. So there's no second loan that's being created. That underlying loan that the seller has in their name or their business name, whatever it may be titled into or named as, that loan is remaining in place, and the buyer is just making oral promises that they're going to continue to make those payments. But as far as the documentation goes, there's nothing actually holding them to that. So we see a lot of investors, rather, find people and distress, it's
Yes.
usually subject to is never going to be your first option.
Right.
If that's something that someone's coming to you and you're not in a bind, you don't want to even consider that. There's no need to. But if every other option is exhausted and that's the only thing you really can do, you just need to be aware that they're not promising they're going to pay your loan. Likely they're probably going to try to turn that property quick before it goes into foreclosure,
Right.
and they may or may not make payments on that.
Wow.
In the interim.
So if I'm the seller in that position and I know my credit is now taking a hit because I deeded the property, but the loan's not getting paid, what recourse do I have?
That's another difficulty with the subject too, is because usually whenever someone buys a property, say mom and pop or your average family buys a
Right.
house, the title is going to be transferred immediately. In Texas, they'll receive title right when they close on it. It's going to be subject to a lien, the deed of trust, which is the security instrument securing the promissory note, right? So if they don't pay, they can get foreclosed on. The title and the debt are one and the same, but in a subject to or assumption, or I guess even in a wraparound, what happens is the title, the ownership of the property is severed and is going to be in a different name than the person who's obligated on that debt.
Right.
And so in a subject to, it's really hard. You don't really have recourse other than just to, maybe bring a claim for fraud, DTPA, which is the Deceptive Trade Practices Act. But those are going to be kind of your go-tos. And so you're looking at, possibly having to litigate this.
And
matter.
you got to hire an attorney, and that's expensive, right? I hear
Yeah.
you guys know.
I mean, it's not cheap.
Yeah.
Justice is
Y'all got to eat
not
too,
free.
right? That's
Yeah.
right. That's right. Well, I think that's fantastic. So for Houston investors, they're buying off market. What are some red flags that maybe they should be watching for?
When people are buying off market, that it could be a great deal. We've seen all kinds.
Sure.
So we've seen just deals that weren't even a thought in the seller's mind until someone approached them and they said, "Well, that does sound great. I'd like to have that extra cash." Those can be gold,
Yes.
right? But when you see people or very aggressively marketed properties, on other websites, not har.com or
Right.
on any MLS,
Right.
you really need to find out what the background is. You need to see if this property's been held by the same owner for, and for how long. Has this property changed hands, or, does the title changed hands numerous times?
It's a great
Is
thought.
there any liens filed against the property or anything that you need to be aware of? You just kind of need to get the full picture of what's going on, because it's hard to tell unless you really know all that information.
Do your homework is the moral of the story.
And engage an attorney, a real estate attorney, or even pay a title company to just have them do a preliminary search.
At what point in the contract would it be appropriate to retain an attorney?
Ideally, before you sign anything.
Okay, don't sign until you get an attorney's opinion.
But I mean, at least prior to option expiring.
Sure.
A lot of people come to us, unfortunately, when they're in a bind, right? Maybe something has gone different than what they thought it would, and then we're kind of trying to do some damage control.
Right.
It's a lot easier to be proactive and make sure everything is good before they sign that line.
Yes.
Before you're binding yourself to something that maybe you don't fully understand. So having an attorney review as early as possible, even before you sign, is always recommended. And we do provide a service where we offer that. We actually
fantastic.
engage with, we have several real estate agents and brokers we work with where they offer a title search free to their clients, right?
Oh, nice.
They eat it, but we work with them
That's a great
and reduce
idea.
the costs. So it's definitely important. And even the TREC contract, it's promulgated by the Texas Real Estate Commission. Brokers, attorneys, non-brokers, non-attorneys, they all have their eyes on it, and it's very comprehensive and thorough. But a checkbox that is not going to make the contract look dramatically different can have dramatic
Absolutely.
consequences. And so it's the devil's in the details usually.
That's the truth. We know that. So I'm curious. I know you said you have a litigating background, and I'm deviating from our question list. So,
No problem.
feel free to pull me back on the rails. But I'm curious, what are some horror stories you've seen?
The worst case, well, horror stories, I have to put them into certain categories.
Sure.
Horror stories regarding just the nastiest family disputes you've ever seen, that would be one. I have seen a 80-year-old oldest brother shoot himself in the head with a shotgun.
Oh my gosh.
After being evicted, subject to a partition lawsuit.
Oh my.
And we had to move all of his stuff onto the curb. And that night, one of the neighbors, who was a real estate agent actually, she wanted to list the property. We exchanged contact information, and later that evening, she sent me a picture of what another neighbor took after this guy had shot himself. He lived, but he shot the front part of his face off. So that was a nasty family dispute.
No kidding.
And that can happen a lot with inherited property, and maybe we'll touch on that later.
Yeah, absolutely.
But some of the saddest things I see is just people being taken advantage of. Wrongful foreclosures. I've seen some really big multi-million, billion-dollar companies that just have a scheme where they know exactly what to do to get people to sign, to induce them into agreements, and they never turn out like they thought it was going to be. And now they're facing foreclosure, or maybe they've been foreclosed on and are getting notice that they've been foreclosed on without getting prior notice. But yeah, we've seen super glue and deadbolts, water lines cut, power lines cut, AC emergency shutoff breakers taken out. I have seen what only could look like a hitman: dark glasses, hat, latex gloves at a gated community entering. And I did identify who that person was.
Oh my goodness.
But I won't disclose it on
Probably
here.
better not.
But he was a real estate broker located in Dallas.
Oh my
working for this lender, multi-million, $100 million lender.
Wow.
His name is public because I filed it in Dallas County District Court. So,
so
if you're curious,
feeling
you can
like
look that
up. Dig through county records. Oh, I'm sure Dallas is an easy county to pull up too on the internet.
Yeah, you can definitely get the dockets. I don't know how easily the public can access the court records, but you can definitely get someone to get it for you. It won't be that hard.
That's awesome. Or not. Don't do anything bad. It'll follow you. All right. Well, so speaking of foreclosure, let's kind of switch gears a little bit and talk about, if you're in a bind, what's a good way to get out of it? Like how should people avoid being taken advantage of, or what's some things you've seen work effectively there?
Definitely, even if everything just looks so clear-cut and black and white, assumptions can cost you a lot of money. And so don't ever assume that, the seller or the buyer or whoever you're dealing with is the honest person they claim to be.
Right.
You can trust.
Trust but verify.
Trust but verify. And, that's a term that we hear all the time, but especially in auditing, right? CPA work. We trust our clients, but we're paid to do a job, right?
Yeah.
So, but yeah, you just need to make sure you really understand what you're getting into. And then if you are in a bind and you haven't sought legal advice previously, you just need to get to one as soon as you can.
That's great.
And preferably someone specialized in that field, not just a generalist.
So one issue we see just far too frequently is an owner of a home passes without a will. And, tell us what happens in those situations. And then I want to talk about how do we avoid them.
Yeah, this is probably the number one issue that comes up. I mean, it happens all the time. It could happen to anybody.
All
right?
the time.
People die, unfortunately.
Yes.
But it's just a fact of life.
Only getting out of life one way.
Yeah, estate planning, it can be a difficult thing for some people.
For sure.
So they just delay it. I'll do it later. well, that time never comes. You never know when you're going to pass. And then, that's it, right?
Yes.
And so the reason why heirship issues can cause can be kind of latent defects is because they don't affect the possession of the property, right? So if grandma owned a house and lived there and then she passed away and then, her daughter moves in and then, her kids then take over, it's perfectly fine for possession. But if you ever need to try to sell that property or you need to try to refinance it and it needs to clear a title company, they're going to say, well, whatever happened with grandma's estate? We see she didn't probate a will.
Yep.
Who are her heirs? And in that case, there's only a few ways you can do that. It's one of the easiest ways is just to do an affidavit of heirship if the family history works for that type of situation. An affidavit of heirship is, I always call it like a mini probate without a will. That's probably a horrible, I'm sure other attorneys would say that is not at all what it is. But really, you're just trying to get to who are the heirs.
Right.
And so when you have the heirs and someone who can make an affidavit, these all have to be, at least the affiant, the person making the statement, they have to have personal knowledge of the deceased.
Okay.
Right? It could be a surviving spouse, any type of family member, just someone who knows them. And if you have all the family history, right, hopefully you're not going back several generations because you're probably going to be looking at a number of these affidavits, right?
Oh, wow.
So we're talking about for one person, it's generally going to be one affidavit of heirship. You have to list who their children are, in certain circumstances, who their siblings are,
Oh, wow.
their marriages, each marriage that they had during their lifetime, where those occurred, when they terminated, was it because of the death? And if all those things work out to where the heirs, which I'll get to how you determine the heirs,
Right.
if all those things work out, you still have to have two disinterested witnesses to read that affidavit and attest to the truthfulness and accuracy. And those witnesses have to have personal knowledge.
And that's our easy way.
That's the easy way.
Okay.
And when I say personal knowledge, for a witness, a title company, which we always want to look to title company standards.
Absolutely, yes.
The statute says an affidavit of heirship has to sit and vest after being recorded for 5 years.
Wow.
Luckily, title companies don't follow that.
Okay.
Right? Nobody really follows that.
Whew.
That's more of just a legal, what the court might rely on. But to have personal knowledge, a title company generally wants to see someone who knew the deceased and knew of their family history for 10 years or more.
Okay.
So a long-term family friend,
Sure.
a neighbor if you've lived in the same spot for a while. Someone like
Something like
that. But
that.
it can't be anyone who has any direct or indirect benefit in that estate.
That's a challenge, yeah.
Yeah. So it can be a tall order.
No kidding.
But then the heirship is just determined. When you go the affidavit of heirship route, you don't get to pick who gets the house. It's determined by statute.
Okay.
It's going to be section 201 of the Texas Estates Code.
Okay.
Which just details, and if you really want some good reading for nighttime, this will put you to sleep.
I
But
have no doubt.
it runs through every scenario
Sure.
of if you had a spouse, if you didn't have a spouse, if you had kids with the spouse when you died, if your kids were from a previous marriage or outside of that marriage.
Right.
And it tells you who the heirs are going to be in every situation.
Okay.
The easiest way is when there's a surviving spouse and they have kids. It's the only marriage they had, and it was the husband or wife who passed.
Sure.
The surviving spouse could make the affidavit, say, these are our kids, get the witnesses to sign. The husband, or surviving spouse rather, would then inherit her share.
Okay.
But if those kids turned out to be from a prior marriage or just outside of the current marriage, not the children of the deceased, or I'm sorry, not the children of the surviving spouse, it gets
Right.
complicated. You could see.
Yeah.
Then the surviving spouse does not inherit the deceased's share.
Wow.
It's actually divided among all of the children, and that's the first run, assuming that's what the facts are. And that could be children, even if the deceased had 10 marriages with 5 kids in each one.
Oh my goodness.
Now you're dividing that 50%, assuming it's a 50% community property interest,
Right.
dividing it among all of the children that the decedent had during their lifetime.
Oh man. What's the most heirs you've ever seen? Do you know?
I probably can't remember. I have seen quite a few. I mean, probably 20-ish, because heirs don't have to
Wow.
just be children. They can
Wow.
also be, let's say that the affidavit of heirship didn't happen, someone passed in the year 2000, and then fast forward to 2026, they're trying to sell a property now.
Right.
And
Oh my
they haven't done
gosh.
anything since the
Yes.
year 2000. Well, some of those heirs, right, even though the affidavit of heirship hasn't been recorded, so title hasn't been perfected in the heirs vest in their ownership immediately upon death.
Okay.
It's just not of public record, and so it can't be insured and pass good title. So let's say, someone, and we see these types of crazy scenarios all the time, but if someone had 10 kids, right?
Right.
Think of,
Yep.
big families from back in the day, and we see it, sometimes. And, maybe 2 of those kids had already predeceased their parent when the parent
Wow.
died in
So it
2002.
goes to their kids.
Well, now you're looking at, we need to do 2 other affidavits of heirship for those deceased
Wow.
kids, but we can deal with those, that's fine. But then come 2026, when we're actually getting to the decedent from 2000's death,
Right.
maybe another 5 of those heirs at the time he or she passed have now passed. And
it
so
gets
we need to
very
look to
messy.
the heirs' children, right? Did they have a probate? It can become very complicated very quickly.
Oh,
So
yeah, that's why you guys have jobs.
that alone would keep us in business.
No kidding. That's no kidding.
But there are other avenues too. Of course, you can probate,
Okay.
even if there's not a will.
We hear probate all the time. Can you give us just a layman's definition and then tell us the timeline you can expect on that?
Yeah, so there's different types of probate. I'll just cover the 2 main ones
Okay.
that you see that aren't, or there's really 3, but if the decedent has a will, that will is a piece of paper until the court, authenticates that it's a true and legitimate will that was signed and is the true intent of the testator, the person
Okay.
who wrote it. So, if all the due formalities, it shows that it's supposed to be a will. It says, this is my last will and testament. Some of them you can just check the boxes pretty easily. But as far as proving the authenticity, hopefully, every will prepared now is self-proved, meaning it's signed by the testator in the presence of 2 witnesses
Okay.
who also sign and have their signatures notarized. So you're still back to the 2 disinterested witnesses,
Sure.
right? But as long as you have that and it's self-proved, whoever the beneficiaries are that you say you want to inherit whatever property, you
That's
just
how
need
it
to
goes.
prove that will is authentic. It's a pretty easy process to prove it up, as long as nobody's contesting, and then the judge will admit it to probate, appoint an executor, likely the one named in the will, and that executor will be responsible for distributing assets, right?
Okay.
If there's no will, then you're really doing kind of the affidavit of heirship, but in a legal setting
Okay.
in front of a judge.
Got it.
Probating a will, if it's self-proof, can be just depending on the court's docket, can be a pretty quick process, 3 to
Okay.
4 months.
Oh, that's quick. Okay.
Yeah, and it's not really, it's almost just a very mechanical, okay, on this date you file this document, and you just, it's check the boxes.
Gotcha.
If it's contested, that's a whole different story.
Sure.
But when there's not a will and you need to determine heirship, and for whatever reason the affidavit of heirship just doesn't work, or you just don't even know that's an option, you can file an application to determine the heirship of an estate and to appoint an independent administrator. You're just trying to get to the same result of an affidavit of heirship. Who are the heirs? But now you're having a judge review and declare who the heirs are in a judgment declaring heirship. When you go through the court, if you don't know who the heirs are, right? If there's some that maybe you just don't know, and that's why you couldn't do an affidavit of heirship, the court's going to have to appoint an attorney ad litem.
Right.
And a lot of times, there's going to be an attorney ad litem anyway, just to verify that maybe it looks like you have everybody, but you've kept out your black sheep brother or sister, right? So the ad litem is going to be appointed That's additional fees that are going to have to be paid, right? He doesn't work for free either. But you basically go through and provide all that information, the family history. The heirs can provide their testimony or support to those facts, and then the ad litem verifies those facts and certifies it for the court. If all that works out, you can get a judgment declaring heirship. That's a little bit longer because now you have an extra step. It's the ad litem verifying and filing their report. Those are a little bit pricier, and the timeline, optimistically, we would just hope that would be within 6 months.
Okay, that's not the end of the world.
That's
not
optimistic,
option
but
A.
yeah, not option A.
So the best thing to do is to get a will done, and then you can go through probate.
Get a will, or there's also some other options.
Okay, tell us what the other options are.
The other options are really done with the goal of keeping you out of probate altogether.
We like that.
Yeah, probate is not that difficult when there's, it's uncontested, and I guess the estate is not overly complicated, but there's other things like a trust, a revocable living trust. If it's just real property that they're worried about, now in Texas we have the transfer on death deed, which it's been around for a long time in a different form called a ladybird deed, but it's now codified in statute, and a transfer on death deed will pass. It's really like a will, but it looks like a deed, but you're listing the beneficiaries for that specific property. And that title will transfer upon the death of the grantor.
Then there's nothing else you have to worry about.
That's
you
it.
Just let it transfer, right?
You let it transfer. You generally do need to file either a death certificate in the property records, or to not have to disclose some of the private information, you can file an affidavit of death.
Okay.
And that will perfect the title transfer.
That's great. So transfer on death deed is probably the way to go if you've just got real property.
That's probably the best tool in the estate planning toolbox for the average person. A trust is not always needed in every scenario.
So a lot of times we get into these real estate situations and we don't even know there's a problem until we're supposed to be closing next week. And then they're like, oh, did you know that this was actually dead grandma's property? And we're like, oh no. So what are some red flags we can look for, or maybe some legwork we can do on the front end to avoid, having to dig out of a mess that takes 4 or 6 months?
Well, always review the title commitment. And this is maybe not on the very front end, but once you have an executed contract, it should be submitted to a title company to open title if it's going through a title company. If there's any doubt about title, it should always go through a title company, right? But a lot of people don't really review the title commitment, but it has a lot of very useful information, and it'll point out a lot of the pitfalls, at least that the title company thinks are potential red flags. And so if you look at Schedule A in a title commitment, the last part of it, or the second to last part before the legal, is going to tell you who do they see as owning this property right now. And if there's deceased parties, it's going to say the estate of, and they'll try to even identify heirs if they're able to, right? Through a probate or anything that's a public record. A lot of people don't even know that information's in there. And so they don't review it. It looks like a lot of legal stuff.
It kind of is.
It is.
It's worth taking a look at.
So once you get your title commitment, which is required to be provided to you within a certain time after that contract submitted to the title company, just take that to an attorney and say, I got this title commitment. Does it look like everything's above board, or are there any issues?
Right.
And we get a lot of clients who just do that to us, with us too. Schedule A is who's the owner, so that's an important one to look at. And then Schedule C on the title commitment will tell you what are the issues that will hold up closing. And these are what the title company is. This specific title company is saying, we will not close this transaction unless 1, 2, 3, 4, whatever is listed in that Schedule C is cleared. And that can be, we see a deed from John Smith, dated this date, but we don't ever, and then he conveyed to so-and-so, and so-and-so is the seller. But we don't ever see a deed to John Smith. We need to clear that up.
Right.
Or, you name it. The errors are endless.
Yes.
Right? It could be anything.
Yeah.
But Even if before you get a property under contract, just some basic research can sometimes help. Look at the appraisal district.
Yes.
Some appraisal districts will show the deed, the chain of title at
At
the
least the
bottom.
last 2 or 3. Yes.
Yeah, a couple of them. For some reason, I think Montgomery County is a lot better than Harris County. I guess it's
No
just maybe
comment.
maybe it's because it's a smaller
Yeah.
county and easier to track.
Right.
But that could be a really good starting point. The property records are public, and so you
Yes.
can go and look up the property records if you want to try to tackle that. It's doable. You just have to maybe have someone show you the ropes if you're struggling, but it's all there and it's all public. Or you can retain an attorney, or just engage a title company without opening title. Just
Sure.
say, I want to buy this property. Can you just check it out and make sure it's good?
Make sure we're good.
It looks like they've owned it for 25 years, and I want to make sure nothing's
That's
changed.
for real. Yeah.
Yeah, everything's just still good with it.
We see or have heard and been warned about title fraud. And so that's definitely something we want to be diligent about. Do your homework so that,
Yeah,
everything's
exactly.
above foot.
Mm-hmm.
Awesome. Well, I want to switch gears again and talk a little bit about LLCs. And we see this a lot with investment properties. So I'm going to kind of put my investor hat on and pick your brain a little bit about this.
Sure.
Can you tell me a little bit, first of all, should we be buying properties in LLCs? We always hear that's the advice. Does it really matter?
So it depends on how much real estate, I guess, investing in real estate the individual's doing. If you're just picking up, it's not good to own a property in your name unless it's your homestead, I guess, because your homestead is protected by homestead law under the Texas Constitution. But when you have investment property, even one, it's a good idea, I guess, to start thinking about, hey, should at least ask the questions. But one of the biggest mistakes I see people make when they buy their first property, or even they have 10 properties, is they think the LLC is the absolute shield
Right.
to liability protection.
I can do whatever I want. I have an LLC, right?
And then they come to us and they're asking why they just got sued when the property's held in their LLC, but then they had some type of altercation personally with a tenant.
Right.
And the answer is the LLC it's not an absolute shield, first of all. There are a lot of requirements that have to be kept. You have to treat it like a business. There's statutory requirements that we can go into a little bit more. But the main thing that people make the mistake of is if you're the only owner, all of your personal acts, everything that you do, all of your text messages or emails or phone calls to the tenant, that's not protected under the LLC.
That's right.
So your actions are your own personal actions, and you have your personal consequences. And so asset protection really comes down to, judgments for injuries or, things that you got sued because a tree fell and hit somebody, or a fence, did something to, fell over and damaged the neighbor's house, or a
Right.
tenant gets hurt. Those are the types of liability protection that an LLC can give you. And it just means that your personal assets aren't on the line, but the LLC's assets are on the line.
Right.
So those can be, taken
Fair
to
game,
satisfy a
yes.
judgment. And that's, if you have one property or 1,000 properties, one issue can expose all of those if they're all in one LLC.
So, and you bring up an interesting point. I know series LLCs are allowed in Texas. Can you tell me a little bit about that and when those make sense?
Yeah, series LLCs, I think they're great, and they're pretty much our go-to for, especially for investors who own multiple rental properties or investment properties. Honestly, even if you're just buying your first investment property and you want to set up an LLC, it doesn't hurt anything to have it originally set up as a series LLC.
So define that for me.
So what the difference is between what I call a traditional LLC versus a series LLC, and this is, now there's different types of series LLCs even. There's
Right.
registered, protected. We generally just use the default, which is protected
Okay.
series LLC. Registered is you're really creating a whole separate business filing for that, and it's getting its own entity number. So
Gotcha.
we get questions about that, but an LLC, I'll keep it as simple, not too complicated, but the series LLC allows you to have an LLC parent, I'll call it, that is formed, and when it's formed, you've added special provisions to that formation that allow that LLC to, at any time in the future, it can designate separate series or branches. Sometimes that's easier to conceptualize, just different branches underneath that LLC, and each one can have its own name. It'll be Series 1 or Series A or Series whatever you want to call it, the address of the property. And as long as that entity, has its own separate books and records, it can be basically treated and regarded as a separate legal entity. That's kind of the gist of some of the special provisions. Like this entity can designate separate series that'll hold separate books and records. The assets and liabilities of this series will be separate and apart from the parent LLC and any other series established.
What would be the benefit of doing a series versus a traditional and just saying, I'm just going to create a whole new one every time?
Simplicity.
Okay.
Simplicity. It used to be
paperwork's already done.
Yeah, if before a series LLC was codified right into the Texas Business Organizations Code, investors would, if they, you don't have to set up a new LLC for every property. You just need to know that, okay, all of the assets in this LLC have been pooled and they're all potentially,
together,
they're lumped together and they're at risk together, right? So it's completely fair to say, well, these are, these 5 properties are low risk, so I can put them all into one. Maybe they're highly leveraged, no equity, but for high risk properties or a lot of equity properties, they would want to set up another LLC, and you could have, there's no definite number, right? It's unlimited.
Right.
But with every LLC, you have Texas, first of all, you have Texas franchise tax reports, your annual public information report. You're going to need to have separate books and records, right? Company documentation, taxes, possibly EINs, all that stuff, right? It's just it's a compliance nightmare.
Right.
A series LLC lets you consolidate everything. At the end of the day, for tax purposes, the IRS doesn't recognize any separate entities. It's one LLC.
You roll it all up, zip it up, and turn it in.
That's all it is. And the series designation and that liability compartmentalization is all just based on Texas statute. It doesn't affect your taxes. And so you just file, like you have one LLC, you do consolidate. At the end of the day, you would just consolidate all the income from your series,
That's
each
perfect.
of them, into one.
So that might be a good strategy to our investors is create the series, put every address in a separate series, and then zip it all up and turn in your real estate stuff to the
It makes it a lot easier. One filing with the Secretary of State, just instead of
15 or however many. Let's talk about investor liability just broadly. What are some things that they should be mindful of? Exposure. And if you have a story, we love stories. So,
well, I'll try to think of a story.
Okay.
While I'm answering the first part, but investors, we have a lot of great investors we work with. We love working with investors because we love working with everybody.
Sure.
We love the satisfaction of helping people. First of all, even if it's just someone get into their first home, resolve a one-off issue that they've had, of any type of real estate nature. Dispute with a neighbor over a fence. We've handled those. Or for investors who maybe they're going to be coming back to do repeat work with you, as long as what they're getting is good, right?
Absolutely.
And they like what legal advice they're getting. Investors, generally, the ones we work with, I wouldn't work with the bad ones, but they're good people, right? They're just out there living the American dream, trying to be successful.
Absolutely.
But you don't know what you don't know. And there's a lot of rules and regulations that can be punitive, and you could be caught in hot water if you don't do the right process. We see that with I guess landlord and tenant is probably one of the basic ones. So that's more common than probably anything. So we see landlord and tenant disputes. I mean, they're everywhere. They're every day. They're prevalent.
Yes.
And it doesn't take a certification class or anything to be a landlord, right? All you need to do is have a piece of property, commercial or residential,
right,
that you say, well, I guess I'll try renting this. Once you get someone in there, you're just expected to know how to do everything legally. And but that's not a requirement to start. And so people make a lot of mistakes. We've handled a lot of repair request disputes, mold disputes, just how requests from a tenant are, maybe they don't go addressed, or they're not addressed timely as they're required to be per the Texas Property Code.
Right.
Especially if it's something affecting the health and safety of the tenant.
Absolutely.
Those become even more urgent, and the timeline shrinks a little bit depending on the nature of it.
Yes.
So, landlords can find themselves in hot water if they're not properly advised on all the legal requirements and how they handle certain things. Security deposits.
It's a huge one.
Yeah, we talk to clients all the time. I have a property management client that just had an issue, and it's not even the same issue. It could be the same broad issue, security deposit,
right?
But every scenario could be a little bit different, and you're like, well, now what?
There's so many different facts that play.
So anything could happen. So you just need to really be aware of what the rules are for landlords in that scenario. Lending. We have a lot of clients who lend money. There's a lot of lending requirements. Can you just loan on an unlimited number of houses each year?
Right.
Or seller finance, right? They think, well, I won't be the lender. I'll just buy the house and then I'll seller finance it. Well, how many times can you do that a year? Do you need to have a RMLO, residential mortgage loan originator, underwrite that loan? Do you need to follow Dodd-Frank? Do you need to verify income? There's a lot of requirements that if you go through an RMLO, they're going to be able to satisfy those.
Right.
But we see a lot of, well-off clients, which good for them. I'm happy for them.
Yes.
But they just want to loan money, and maybe they're not following the requirements, or maybe they're not even protecting themselves with a lien on a property. They just take an unsecured promissory note. And so you just want to make sure you're doing everything you need to do to make sure you're protected.
We've seen it with landlords that are looking to, liquidate their portfolios, and they think, oh, I'll just seller finance all of these. And it's like, oh, be careful.
Yeah.
Or
that'd trigger it immediately.
Absolutely.
Oh,
so many.
Lease to own, contract for deed, lease option, lease with purchase option. All those are potential huge they have potential huge pitfalls. Those are.
Have you? I have personally not seen a way to legally do a lease to own.
There are options. Generally, it's a 6-month cap.
Okay.
So you can't.
It's very hard to feel secure about somebody leasing for 6 months.
Well, and people don't generally follow it, and so that's where they get in trouble.
That's what I'm like. Have you seen? Yeah, I didn't know.
We see. I'd say. All of those types of transactions are lumped together in the Texas Property Code as executory contracts, meaning they're a contract for property, but after the closing, there's still things that need to be performed to finalize this. A contract for deed is the most common we see, and it's you sign a contract to purchase a property, and you don't get title right away.
Right.
It's like a layaway. Right, you make.
That's a great way to put it. Yeah.
Yeah, you're making payments towards the property, and once it's paid off, you can, hopefully the seller is still around, which is also another, potential issue. What if they pass away?
Right.
Who's going to transfer the property? The seller's going to need to determine who their heirs are. Do they have a will? That's a whole nother issue. But you don't have actual ownership of the property in a contract for deed. All you have is an agreement that I'm going to pay, and then when I'm paid off this this amount that you've sold me the property for, you're going to transfer the title, as opposed to what the normal process is of get the title
Right.
immediately and it's subject to a lien. So, yeah, I tell people to stay away from those, because we've had clients who, they've bought on a contract for deed. Next thing they're getting an eviction notice, which you actually can be evicted
Right.
on a contract for deed. There's statutory requirements. Have you paid 40 months of payments? It's just way more
Which can you
complicated.
imagine? Yeah, absolutely.
But it's also opens that door that people being taken advantage of.
Yep.
Like I mentioned before, we have clients who are always current on payments, and now the seller, who still has title, is trying to sell the property to somebody else. Right? And
Unbelievable.
saying, "Oh, your lease is ended." I bought it.
Right,
I
right.
own this property.
Yeah, I
You're not
paid
on the title.
way
You're
more
not on-
than, yeah, absolutely. Well,
They're a mess.
and then that's so scary because a title company is not going to even have record if it wasn't recorded. So
Right. And
it's
if
so
it's
scary.
if you have to do a contract for deed where you're not getting the actual deed to put the title to the property in your name, get a copy of that contract and record it with the county
Oh,
clerk.
that's a great advice.
So it's like you said, if it's not
You've got a
recorded,
paper trail to just
record
protect
it.
yourself.
Because then they can't come back and say, "Oh, this was just a
We
lease."
didn't know. Yeah. Oh, man. I'm sure you've seen so many things. So I want to ask you, and I'm totally putting you on the spot, but tell us another story of just like, I want to hear a landlord-tenant one. So we do property management. I told you that. And so we see all the things, right? And I tell other agents, we get a lot of our business from other agents because most brokers aren't crazy enough to want to go do property management because it is so litigated. So tell me a story.
I'll tell you one that I had kind of briefly mentioned earlier, but recently we did have one of our clients who's a property management company. They manage a number of multifamily properties.
Sure.
And they had one of the tenants. I don't know if it was a married couple or if they were divorced. I don't know the nature, but it was on the news, and I got an email from the client shortly after that the woman had shot the husband right there at the apartment, and she fired up to the second floor, I think, from the parking lot. I think that's how it happened. But the guy died. I mean, she killed him right there, and this was recent. So that's that's tragic, right? But as a landlord or a property manager, it's like, well, I've never had anyone kill someone else on my property.
Right.
What's
the
protocol here? Yeah.
Well,
what do I do? You probably just need to call and get some legal advice.
Right.
Call an attorney. Because that was a matter of first impression for me.
Right.
So I had to do my own legal research on it. But the other one, I guess I'll just mention without getting too much into the weeds.
Sure.
I was personally affected by this, where I had to file charges.
Oh, no.
Against another attorney.
Oh, dear.
Who, as of, I guess, just a few weeks ago, I probably have checked the district court records again, and he's still out with 3 warrants.
Oh, my gosh. So it's important to know who your attorney is, too.
Yeah, this was this was an investment company that we represent. They have hundreds of properties. Very honest, above board.
Sure.
They follow it. I mean, they're to the T.
Right.
And if they ever feel like they're missing something, they call me. And so we talk a lot.
Right.
And I love working with them. Well, they had a kind of a new issue for them where there was some family violence that occurred in one of the rentals.
No.
And it wasn't a married couple, it was boyfriend and girlfriend, but the girlfriend had received a protective order from a court.
Okay.
And in that protective order, the judge signed a kick-out order for the male.
Okay.
So he had, 24 hours or whatever,
Yep.
he's got to go. And his attorney, I was not part of the family, violence dispute.
Sure.
I just came in after the fact on how do we handle this.
Right.
And so the attorney that represented the male said, well, you can't be here, so I'll hold it down for you. This attorney, because the lady she said, well, I'm not staying here. He knows where he knows
Right.
the address here. So
Right.
she
And
moved
that's
out.
a easy get out of lease.
Yeah, and so
Yeah.
she's entitled to terminate, and she was moving out. He's not relieved of his obligations
Right.
under the lease.
Right.
And but he has a kick-out order. He's got to leave, but that's kind of a breach, right?
Yeah.
So he's done things that have created more liability for him, civil liability.
Right.
Well, his attorney said, I'll hold it down. His attorney moved into the property, brought in furniture, a Nintendo Switch, guitar, bed. I mean, he was just squatting there. And my
Oh my
client
gosh.
called me and said, a neighbor just called and said there's somebody at the house. So I said, well, call the police.
Right.
So they called the police. It was the attorney, oddly enough.
Wow.
And
I did not see that plot twist coming.
and the attorney, the police showed up and they picked him up for a criminal trespass. He got
Wow.
arrested. They towed his brand new Nissan Versa. He had like a new car, but they towed his new car, and all of his junk was still left in the house. And so I spent the next 3 weeks after he got out, right? He got out on, I don't know if it was no bail or maybe I think it was on his own recognizance, so no bail essentially. I said, well, we need to coordinate a time. You need to come get your stuff. And it was, dealing with them was horrible.
Oh, I can only imagine.
There was a girlfriend that was cursing me out on the background. I mean, it was just not something you'd expect from an attorney. But eventually we coordinated a date. We said, great. Wednesday, 12 o'clock, this date, perfect. I told my client, have some of your worker guys, have the guys that go in and kind of work on the properties.
Yeah.
Just load everything up, wrap it in plastic bags so it's not going to get wet in case it rains, because it looked like it could have rained that week. And just put it out on the side of the gate. It was a big kind of rural property.
Wow.
And it was a trailer with a horse stable. It was a big property. I said, just put it by the gate and, about this time, and he's going to swing by at 12 p.m. to pick it up. Well, they didn't show.
Shocker.
Which, I mean, that didn't affect me.
Right.
But then it did rain later that week. And I got a nasty email, or I started getting a lot of nasty emails and nasty phone calls. I guess all his stuff got wet. But he began harassing our firm to the point where he was calling 15 times a day, cursing me out, cursing out the staff, giving racial slurs to the staff.
Oh my gosh.
Emails, I would never put anything in writing, even if I wanted to curse someone out, especially another attorney, which I wouldn't. But
come
why
on.
put it in writing?
Right. Oh,
And
man.
So I had tried to file charges, and I met with Precinct 4 constables, Harris County. They said, well, did he say he was going to kill you? I said, well, let me listen through the recordings.
That's the bar.
No, he said he was going to beat me into a bloody pulp. He was going to do this, but never, I'm going to kill you, until one day we finally got it.
Oh, and then
he said, I'm going to kill you. Recorded. I took it back to that constable, and they charged him with terroristic threat.
Wow.
Which is still pending because he's still out. That was a year ago.
Oh my goodness.
And if you come to our firm, you'll see I do have the charging instrument framed in the front office, naming me, saying that he threatened to murder Michael Paul Goehring.
Oh my gosh.
I just thought that was needed to be framed.
Yeah, some things need their place. Wow, that's crazy. That's a great story. Thank you for sharing. I think we're out of time today. This has just flown by. We had so many great conversations. I appreciate you coming out. We'll have to have you back again.
Sure. I would love to be back.
Yeah,
thank you so much.
Absolutely. Well, I am Sarah Lerner with Real Best Property Management, your host today for Housing Houston. This is Michael Goehring, and we are saying goodbye. Thanks so much.
Thanks a lot.